Welcome to the next episode of Called to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we are speaking off the cuff and without the benefit of footnotes, and nothing that we say should be taken to have been thoroughly peer-reviewed. I'm your host, Dr. Juliette McIntyre, Senior Lecturer in Law at the University of South Australia. And joining me today is Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and Ntina Tzouvala, Associate Professor at UNSW Sydney. Shout out to UNSW, we have all your bases covered. So, as you are no doubt aware, over the Easter period, Pope Francis passed away, and at the time of recording, a mere few hours ago, a new pope was elected by the conclave. So we now have Pope Leo XIV, who I believe is originally from Chicago. And so this got the Call to the Bar team talking, though, about, what is the Vatican? What is the Holy See? These have an unusual status in international law. And naturally, of course, that conversation led to a further conversation about stuff like the Sovereign Military Order of Jerusalem, of Rhodes, and of Malta, who you may otherwise have heard referred to as the Knights of Malta or the Order of Malta. Because let's face it, we're all huge nerds, and that's the kind of stuff we think is fun to talk about. And so we thought it might actually be fun to do an episode on this. Let's spend some time talking about these international law oddities. What status do they actually have, and why does it matter? And on that second point, I do want to just have a warning to our listeners that we will be touching upon some material that could be triggering when we discuss the Catholic Church. So please make sure to prioritise your own health and safety. But before we get down to business, our traditional first question. Guys, what you drinking?
I'm afraid I'm just drinking water. I had a weird morning in which I woke up and then I slept again. But I am drinking water from a really fun mug with flamingos. So obviously the listeners cannot see that, but hopefully it makes up for the boring nature of the beverage.
It is a very cute mug. I can guarantee our listeners that much. Doug?
Yeah, I'm at home nursing a cold, possibly the same thing Dina has, as I woke up, functioned for about an hour, and then fell back asleep again. So I'm also a hardcore H2O drinker today.
Actually, I'm rounding out the water beverages, so it's a good thing we're staying hydrated here at Called to the Bar, but it sounds like you should maybe be on the lem sip or something, Doug. But look, let's get into talking about this election of the Pope and so on. So what is interesting here is that the Pope, like his predecessors, isn't going to be only a religious leader, but he's also now a head of state. And so, Dina, could you explain to us why and how this is the case? He's just been elected a head of state, but by a bunch of men wearing red robes.
That's right. And he's actually been elected as one of the few absolute monarchs that are left in this world. So it's an absolute monarchy. So yes, we have a peculiarity here, which is the Vatican City, which for those of the listeners who have been in Rome is basically like 2 blocks downtown in Rome. There is no border. You don't know when you're crossing, but it's basically a few blocks in the middle of Rome, are actually arguably, and I say arguably because there is some controversy, an independent state under international law, and the Pope, therefore, is the head of state and arguably enjoys head of state immunity under international law in that capacity. And I'm saying arguably because obviously there is some controversy about whether the Vatican City actually fulfills the Montevideo Convention requirements, right? Whether it really has, to refresh the memory of our listeners, a permanent population, a defined enough territory, an independent, an effective government, and independence in international relations, right? But I would say it does have widespread recognition, and it especially has recognition as a state by Italy, right? Which is obviously the most concerned party here. So the background for this is, I think we often forget it, how profoundly, Eurocentric the origins of international law are. And I don't mean just Eurocentric in the sense that it prioritized European or Western interests, but also that it developed to a significant extent, trying to deal with problems that emerged in the late Middle Ages and early modern period on this small Asian peninsula that happened to win the lottery called Europe, right? So during the medieval times, the Pope was both a spiritual leader that claimed jurisdiction over Christianity and to the extent over the world, and we are going to get to that, but he was also the absolute monarch of the papal states, which were, to the extent that any medieval community was, somewhat territorially based. So you could roughly pinpoint on the map where it was, within which he exercised both, of course, spiritual leadership, but also like pretty secular forms of governance, right? As we can imagine, with the rise of nationalism as a political force, especially in the 19th century, like late 18th and early 19th century, competition started amassing over the territory of the papal states. And by 1870, basically the only part that was left was a small chunk of what is now Italian soil around and including Rome, so much bigger than the current territory of the Vatican State, but still, a small chunk of Italy. Italian nationalists did not love that because it was like, for those who can look at the map, it's right in the middle of Italy. Rome is right in the middle. So they sent the army to basically conquer. Obviously, the Pope did not have a huge army to resist, but he put up resistance just to show that this was conquest by force, right? That this was not some sort of peaceful incorporation into Italy. And between 1870 and 1929, the Pope was basically saying that I am basically the hostage of the Italian state. He had not recognized the authority of the Italian state over himself and over that particular territory. Now, in 1929, if you want to annoy any, Catholic Church fans in your family, Italy was ruled by the fascists, by Benito Mussolini. And the Catholic Church and fascists did not have necessarily an easy relationship. It wasn't uncomplicated. But what was uncomplicated is that they both despised socialists and communists more than they despised each other. And that can bring people together, So they basically decide that they have to settle the issue of the territorial authority of the Pope, and they get together and they sign the Lateran Treaty of 1929. And on Article 3, and I'm quoting now, Italy recognizes the full ownership, exclusive dominion, and sovereign authority and jurisdiction of the Holy See, we will get to that later, over the Vatican as at presently constituted, together with all its appendices and endowments, thus creating the Vatican City for the special purposes and under the conditions hereafter referred to. So basically, Italy ceded a part of its territory to form the territorial basis of a state that it recognized as sovereign. At the same time, if you read through the Lateran Treaty, it becomes obvious that the Vatican City has the peculiarities that other so-called microstates have, which is there is explicit agreement, for example, that the Italian police has jurisdiction over the St. Peter's Square. And it is also agreed that Italy will provide a number of central functions, things like electricity at the time, telegram, currently telephone, it will build a railway station, etc. So like the relationship obviously based on law, left a considerable degree of state functions, or delegated a considerable degree of state functions to Italy. And that remains the case to this day, right? And that makes sense, obviously, both for Italy and for Vatican City. And that's, to get back to my initial point, that's partly where some doubts about the statehood of the Vatican City come from, right? Those who have questioned that the Vatican City is actually a state have said that, in reality, does not possess an effective government because core functions such as policing are actually performed by another state. But I would say at the same time, in one way or another, a vast majority of states, including Italy, which is the concerned state here, do recognize the Vatican City as a state. I think that's about it. And I can then say more about how this statehood of Vatican City has become relevant more recently, but that's basically the story. So it's basically, to an extent, something that comes from the medieval times. And it's one of the few examples, basically, where nationalism did not succeed, or it succeeded militarily, but it decided to nevertheless give some concessions to forms of statehood and political community that were not based on modern nation-based principles, right? And rather on religious forms of authority, because of course there is a territorial base, but let's be honest, the reason the Vatican City is a state doesn't have to do with its immense territorial control of St. Peter's Square.
Yeah, that's right. So there was a couple of things that's really stood out to me there in that terrific description. So one is how recent, actually, maybe people didn't realize how recent the sort of solidification of this status of the Vatican actually is, given how old the Catholic Church itself is. So that's my first point. My second point is that, of course, the Montevideo Convention came after this creation of this Vatican entity. So it's maybe not necessarily surprising that it doesn't match up directly with the criteria, right? But then the other thing is, of course, we always tell our students, oh, government is the least important one of the criteria, right? Because there's plenty of states around the place that, for one reason or another, don't necessarily have an effective government. So it's interesting that you said it's the government bit that tends to suggest maybe that the Vatican is not a state, for those who want to make that argument. And then, of course, talking about the Pope as this head of a religion and the way that was a basis for power here, because there's so many, I mean, obviously I do courts and procedure and stuff, and there's so many arbitral agreements from the medieval era where you could appeal to the Pope if you didn't like the decision. So you would often go to some form of monarch to get a dispute resolved between two other monarchs. And then if you didn't like that decision, you went to the Pope. And so the Pope had this authority that was even sitting above the recognized sovereigns a lot of the time, of course, depending on which religion you prescribe to. And so, so the Catholic Church has got this dual existence, this dual identity in international law. It's both a state, Vatican City, and also this sort of peculiar non-territorial legal person, which is known as the Holy See. So could you explain to us a little bit more about what that's all about?
Yes, that's where things, I think, get really complicated, because the Vatican City is an oddity, but in a sense, microstates exist in international law, right? In many respects, like Monaco or Liechtenstein in Europe are not that dissimilar to the Vatican. They're a bit bigger territorially, but they also, for example, have given some of core state functions to other sovereign states that exist, that they exist basically within. So that is not unique. I think why we're getting pretty exceptional is that the Holy See, SEE for our listeners, which is basically like the governing body of the Catholic Church, also has, independently from the Vatican City, international legal personality. And as you said, Juliette is an international legal personality that is not statehood. How do we know it has international legal personality? Well, it signs agreements with states that they're called concordats, They are not treaties in the sense of the Vienna Convention on the law of treaties, but they're treaties that states treat consistently as binding, and they treat consistently as in being international agreements. They don't treat as like domestic law instruments, right? And they regulate things like the tax status of the church, or they regulate things like Catholic schools or Catholic missionaries, etc. So, and they are understood to be binding and international in nature. And in order to be able to conclude agreements that are binding and international in nature, it means you possess some degree of international legal personality that, of course, is not the same degree as the state, right? It doesn't mean that the Holy See can do every single thing that a state can do under international law. And again, in a sense, that is a reminder of, as you said, Juliette, how recent statehood is in international law and how recent secular, bureaucratic, territorially bound authority is in international law. For centuries, especially again during the late medieval or all the medieval and early modern period, the Pope claimed that he had jurisdiction over the whole Christian world, right? The Res Publica Christiana, everywhere that they were Christians, the Pope claimed that he had jurisdiction. He claimed that he even had jurisdiction where Christians were not. For example, in the Americas, where the papal bull purported to be carving out the so-called New World between Spain and Portugal, right? So these were forms of authority that, as you say, do not fit neatly between our current understanding between about the distinction between religious authority and secular authority, right? The fact that you were a religious leader didn't mean that you didn't have actually authority to deal with things like territorial disputes or other disputes amongst monarchs, right? And basically, the idea is that, again, due to the profoundly Eurocentric nature of international law, the Catholic Church ended up being the only religious body that, well, together, of course, with the Knights of Malta, but like the Holy See, that they claim international legal personality, right? And for example, the Holy See is, with some ambiguity about whether it does so as Holy See or whether as the government of Vatican City, but it has permanent observer status of the United Nations. And also, and we can discuss that a bit more later, it is unclear, like the Catholic Church signs into treaties, and it's not always clear if it does so as the government of a state, Vatican City, or whether it does so in its nature as a peculiar non-territorial international legal person. Generally, the Catholic Church prefers to conduct international affairs under using the words Holy See, but it's not always clear if that's the government or if it's the Holy See in its own right. And sometimes that can create actually quite tricky international law questions.
Yeah, because it's not as though, I mean, you can have a religious-based government. I mean, this is a bad example maybe, but the Taliban, of course, is a government that is based around a particular interpretation of a particular religion. But the status of Afghanistan as a state is quite a separate question from how they want to run themselves from that point of view. Whereas the religious status of the Holy See and its existence as a state or otherwise seem to be much more closely intertwined. Exactly. Yeah. Doug, did you have something you wanted to add on this point about statehood and how that works?
Yeah. So there were just a couple of points I wanted to sort of tease out here. The first, I mean, is just to loop back in a sense to why we're having this conversation and why things like the Holy See or the Knights of Malta are difficult to classify. So in a sense, we're having this conversation, right, because we've taught public international law, and there's a chapter on statehood in the textbook you give students, and it basically says, so states are the original international legal personalities. They have sovereignty. Everything else derives from them. Okay, international organizations have, as we've just been talking about, international legal personality. They can do some things on the international plane, but they don't have all the attributes of sovereignty. And you explain that by saying international organizations are created by states, so they exercise powers delegated by states. And then you have the little bit at the end of the chapter goes, oh, and there are these oddities that have international legal personality but aren't the direct creation of states. And that's the other, like the bucket of stuff we can't explain. And as Ntina has sort of put it so well, this is because actually states haven't always been there in the way we understand them now. The bucket of other, these oddities, are things that remind us that the territorial state that satisfies the Montevideo criteria is a relatively recent invention in world history. And other, sovereignty used to be, and the sources of power in what we would now call international affairs, used to be sort of much more diffuse and amorphous and varied, and there were all sorts of political or other communities that had international status. And so the others are in some ways, more original than states, right? That they have this continuity that states don't. Also, when it comes to things like the Holy See, I mean, I just wanted to relate this back to earlier episodes we've done, for example, on the status of Palestine. So, we can say, oh, things are a state if they satisfy the Montevideo criteria, territory, population, stable government, independent ability to conduct international relations. But that's also just a heuristic, right? It's a useful shortcut because that's the declaratory theory of international law. You have to meet objective criteria, then you're a state, and the fact that other states recognize you then is kind of like, the cherry on the cake. It's not necessary you're objectively a state or not, which I've always found profoundly unconvincing, right? You're a state if other states treat you as one. Sure, that may mean that, there's a degree of relativity to the powers you can exercise on the international plane, perhaps. But it's also not just a question of formal recognition, right? Like, in periods where the Arab world refused to accept the legality that Israel had the status of a state, right? They would still say, oh, but Israel cannot commit aggression against us, right? So they're still acknowledging de facto that it was a state, even if they refused to acknowledge it legally. So that also, in my mind, goes very much to kind of the constitutive theory of recognition. So essentially, at the end of the day, things are states and able to conduct business on the international plane if they are treated as such.
Yeah. It's a country club, and if the other members agree to admit you to the club, then you're a member.
Yeah, and it's then a bit too late to argue about, but, do you really satisfy the criteria of membership?
Yeah, for sure. And so this is okay. So this actually takes us into we've talked a little. We've mentioned the Knights of Malta, which I don't know about you guys, but it just makes me think like Da Vinci Code levels of sort of intrigue. This group, this entity, I don't know what word to use for it, is often described as sort of this quasi-sovereign or anomalous entity in international law because it's got an even more unusual story than the Vatican in some respects. So could you explain what we mean when we describe it as quasi-sovereign and in what sense, if any, can the Order of Malta be considered to be a sovereign today?
Right. So, I mean, we've already referred to it by its full name, the Sovereign Military Order of Jerusalem, Rhodes, and Malta, which in a way kind of builds in its history. So it was originally an order established in Jerusalem to provide medical assistance to anyone regardless of their faith, but later acquired territory. It ruled Rhodes for a period and then for nearly 250 years, ending in the late 18th century, I believe, Malta, hence now Knights of Malta. And so it lost that territory to France. There was a period when There were kind of treaty commitments to return Malta to the Knights of Malta should France be defeated. But then with the settlement after the Napoleonic Wars, that prospect went away and it was left as a deterritorialized entity. But the thing is, while it had acquired territorial government at a certain point, that hadn't been how it had started, right? So it had these various statuses over time. So it's sort of referred to as being sort of quasi-sovereign in the sense that it exercises, and this goes to some of the points Dina was already making, functional sovereignty, right? It is treated as sovereign in respect to the functions it carries out, which are largely of a humanitarian nature. And it can enter agreements with other states as a sovereign, and it issues passports, for example, and the two buildings that constitute its headquarters in Rome are apparently regarded as extraterritorial.
Mm.
And notionally, I think the three highest office holders of the Knights of Malta are described as citizens. But otherwise, it's essentially an international aid organization. And like the International Committee for the Red Cross and UNESCO and the Olympics Organizing Committee, it has observer status at the United Nations, but not observer status as a state, right? It's just declared to be a permanent observer in the manner that a number of other organizations are. So it's interesting that it's still treated as a sovereign order, but it exercises. So, I mean, one of the things James Crawford used to say was that, sovereignty, like property, is a bundle of rights. You can disaggregate bits of sovereignty. So it has sovereignty in respect of its internationally recognized functions. So in that sense, it doesn't have plenary sovereignty. It isn't sovereign in the sense of a state, but it does have recognized international legal personality and the ability to do certain things on the international plane in relation to its functions. Hence, quasi-sovereign.
Okay. So you mentioned that, I'm going to come back to the sovereignty point in a minute, but you mentioned that historically the order had ruled over Rhodes and over Malta and then lost its territorial base in the late 18th century. But you also said that they've got this potential to maintain diplomatic relations with other states. They've got this permanent observer status at the UN. So what is it in legal terms exactly? Spell it out for me like I'm a first year. What is it that distinguishes this from full statehood? And maybe like what's the relationship between second follow-up question, sorry, I'm making things up as I go, is can you talk about the relationship, if any, between the Vatican and this order of knights, or like a comparison between the two of them or something like that, if that makes sense?
Right. So the strongest argument that the Knights of Malta are not a full sovereign is that to be sovereign means that you admit no higher authority.
Mm-hmm.
Whereas the Knights of Malta understand themselves to be subject to canon law, and the law of the Catholic Church treats the Knights of Malta as a subject of canon law that is subject to, and I'm presuming it's the authority of the Holy See rather than Vatican City in this context. But
right.
even within canon law, though, canon law acknowledges, as it were, sort of the independent entity of a number of religious orders. Even within that system, the Knights of Malta is regarded as special. So generally speaking, though, that is taken to be the argument in the conventional international law literature to say that the Knights of Malta can't be a full sovereign because, as it were, they are not entirely independent of the authority of another internationally recognized entity, which would be kind of the final and most pivotal element of the Montevideo criterion. The one that's often overlooked is the ability to engage in international relations independently. So it's that notion of independence that's challengeable. Now, there's a minority theory, I believe, in some of the Italian scholarship that says, oh no, you need to understand this is a difference between, as it were, the spiritual and the temporal, that temporally, actually, the Knights of Malta should be regarded as a full sovereign because they are, in effect, independent. It's just that they are spiritually subject to canon law and the law of the church. Now, as I understand it, that's a minority position. So generally, the argument is taken to be that the Knights of Malta cannot be a full state, not merely because they don't really control any territory other than two houses and so on and so forth, but that they are not entirely independent of the legal authority of another international person.
Right. Okay. So the Vatican and the Order have got this relationship, and they're subordinate to the Holy See to a certain extent. And
Yeah.
so
Also, sorry, I just want to raise a sort of really, really geeky side note.
please do. That's what
So,
we're here for.
okay, so this is going to start by sounding weird, but I'll get there. I am a film noir fan, and obviously one of the great Bogart movies is The Maltese Falcon.
I love that movie.
Yes.
It's also one of the original MacGuffin movies, right? Everyone's running around to try and get this thing, the Falcon, which may or may not be real, may or may not exist. When you do find it, may be real or a fake, blah, blah, blah. So, the action, the status of the thing in the movie, the Maltese Falcon, is essentially irrelevant. It's just a vehicle for the plot. Nonetheless, it's based on an actual story about a jewel-encrusted gold falcon that went missing in 1539. And this story is real. Because actually, you could raise a question about whether the Knights of Malta were ever truly sovereign or whether they held Malta on a lease, because they were tributary.
Not Dickens.
Yeah, they were tributaries of Charles V, the King of Spain and the Holy Roman Emperor, and their tribute annually was meant to be to give him a Maltese hunting falcon, right? But then one year they decided they'd really push the boat out and make this jewel-encrusted gold falcon and go, haha, you thought you were just getting a hunting falcon, but no, this is how much we value you. And the ship upon which that was sailing to Charles was attacked by pirates. And the Maltese Falcon disappeared from history, hence allowing it to be the MacGuffin in first the novel by Dashiell Hammett, and then in the movie. But this is a long-winded way of me making the point of saying everyone sort of goes shorthand, oh, the Knights of Malta were sovereign over Malta, therefore they're a state. And I'm like, that sounds to me more like a lease of territory.
Yeah.
Like in modern terms, you might call that a kind of lease of territory by an international organization.
Yes.
And you might sort of go, well, was Charles V really the sovereign over that territory in some kind of reversionary way? I have not researched this anywhere near enough. This is definitely a moment when I'm speaking off the cuff and without benefit of footnotes. But so just going to the weirdness of pre-modern sovereignty, right? Like, they controlled Malta for the price of a hunting falcon.
Yes. Yeah, that's right. It's a peppercorn rent.
And also the sort of like, it's easy to forget that, like, again, until like 10 minutes ago, what sovereignty meant was so different to what we understand today, right? It didn't necessarily mean undivided authority. Like, it was totally imaginable to people that more than one actor could be sovereign in roughly the same territory. And it just
Absolutely.
meant that they were separating, basically they were separating different, as you were saying, like different like sovereign functions. And therefore it was entirely possible at the time, perhaps, that they were both sovereign over Malta.
Right.
And that was a thought that people could hold in their minds, in a way that it is true that since at least the 19th century, or a bit maybe later, this starts becoming a paradox, right? You can't have more than one sovereign over the same territory.
Okay, so that's fascinating. So I want to know then, in our modern understanding of statehood and sovereignty, do you think nowadays it's possible to reconcile this idea that the order is subject to the Holy See, it's dependent, it's ruled by canon law, with its status as an international legal subject? Because I can't think of any other example where you've got this two-tier system and you still have complete, full international legal recognition as a sovereign.
Well, again, I guess it wouldn't be compatible with statehood, but again, on my how do other states act kind of constitutive rather than declaratory approach to these things, other states treat it as an international subject, at least for a series of functional purposes. So on that basis, I'd say, the basic actors of the current international legal order treat that as possible. So there we are. I'd say, yeah, not a state, but a functional sovereign appears to be the conventional view.
Mm. And so, I mean, it's an anomaly, but I mean, I guess other states do have weird relationships. You know, we're in Australia, we're part of this Commonwealth that has the King Charles as our sort of head of state, which, you know, some might suggest means we're not fully sovereign and independent, but most people would suggest that's a nonsense. So,
Well,
yeah,
actually, that's a good point, though, in the sense of that kind of Australian constitutional law question or historical question of at what point did Australia become independent? Because, you know, even our constitution, we've had to reinterpret the external affairs power as being a power to conduct international affairs, because it was originally presumed at the time of federation that we would remain an entity within the empire, and that most of what, you know, for most purposes, actually the UK would continue to exercise significant authority on our behalf on the international plane. And in terms of, you know, not acknowledging any superior, we only abolished appeals to the Privy Council in what, the 1970s? And I mean,
the 1980s, I think.
right.
Yeah.
And I mean, and again, you can say, oh, well, you know, recognizing or outsourcing your highest court of appeal to be the highest court of another state is okay. Lots of independent states in the Caribbean still have the Privy Council as a final court of appeal. But, you know, there were some very interesting questions actually around the status of early naval vessels operated by Australia and who would be internationally responsible for them.
Mm.
Whether the empire would mean that the United Kingdom would have been internationally responsible for them, or whether Australia was, you know, a full international legal subject in that regard. But then, you know, the First World War broke out. Everyone subordinated their shipping to the empire, and that problem wasn't around anymore. And then thereafter, we did kind of put our own navy on a more independent footing. So these questions don't, in a sense, you know, there isn't some kind of clean break at the Treaty of Westphalia where suddenly everything's a state and there are no oddities.
Yes.
Or that like everyone is either a state or not an international legal person at all, right? I think that's
or only an international legal person insofar as you were set up by states.
Yes. So that's the thing. I think once we distinguish between international legal personality and statehood, suddenly independence is not that important, right? It can be one criterion, but even without going back to Australia's historical relationship with the British Empire, even contemporarily, you know, Bosnia, based on the Dayton Accords, is functionally extremely dependent on Germany, right? Basically, the highest authority in Bosnia remains like this weird German chancellor that reigns pretty like in a pretty like dictatorial almost way.
Oh, the high representative.
Yes. Yeah. Who is basically, if you're like a semi-retired center-right German politician, it's a great like retirement gig in which you go and you're basically the High Commissioner of Bosnia. But nevertheless, as Douglas has said, you know, Bosnia claims itself to be a state and pretty much every other state recognizes it to be so, even though it has, based on the Dayton Accords, a very significant limitation of its sovereignty, both in terms, obviously, of the High Commissioner, but also in terms of like the Dayton Agreement determines a number of things concerning the finance of Bosnia, concerning its currency, concerning its election and relationships between different ethnic and religious communities that we normally wouldn't consider compatible with full sovereignty, but Bosnia's status as an independent state is not really contested, partly, and I agree with Douglas, due to being accepted for membership in the United Nations and due to recognition by other states.
Yeah, that's fascinating. I didn't realize the full extent of that. That's really quite something.
Look, it's also, I think we can have also this discussion about the problems that this raises, right? The forms of state.
Yeah. So this
So,
is what
I
I
mean,
was. Oh, sorry,
we,
go on, Doug, and then
well, I
yeah.
mean, and I mean, this goes back to some of the questions touched on by Alex Green in the episode we did on the Fallopile Union Treaty about, what is the spectrum from being a sort of completely dependent territory of an existing state through to a completely autonomous state. And I think this just underlines the theme of the episode, that things are actually quite messy. So I seem to recall Imogen saying once, I can't recall whether it was on the podcast or not, but that when she studied chemistry, every year they'd say, here is a basic model of the atom. And then next year you'd come back and they go, okay, so the model we taught you last year was an oversimplification. Here's the new thing. And then the next year would be, okay, that was an oversimplification. Here's the new thing. So one of the problems we've got in thinking through these messy categories of sovereignty is that actually we don't do that bit. We just kind of go, here is the oversimplification that's in the textbooks. There are states and non-states, and international organizations have international personality only to the extent they have it delegated by states. Oh, and then there are these anomalies, but we're just going to leave it at that, right? We don't actually do the work of building the theory that reconciles everything. We just stay with that kind of first cut, first year chemistry version of what's going on. Anyway, I note the time, and Juliette, we're pulling you off course.
Yeah, well, no, so I just wanted to, I mean, because this has all been super fun, right? We're talking about like literal gold falcons and pirates and knights and all of these crazy historical anomalies. And so it's fun, it's peculiar. And you're right. I mean, some genius out there has a fantastic PhD thesis to write a theory that links these things together and explains the idea of sovereignty in more depth. But, let's take things into a serious space for a minute and ask, is this just completely useless from a practical point of view, or are there actually some important consequences that come from the status of, in particular, the Holy See as this anomalous entity in international law?
Yeah, just to repeat, Juliet, your point in the beginning of this episode, which is suddenly things are going to take a much darker turn, right? So basically, this was kind of a weird curiosity until obviously the child abuse the child abuse scandals, and especially the cover up by the Catholic Church started being revealed across the world, right? And we know there is hundreds, if not thousands, of children who were at the care of the Catholic Church in one way or another and suffered great harm, and that harm was largely unaddressed and actually exacerbated by the behavior of the Catholic Church in basically moving people around and giving them the opportunity to harm even more children. And that actually became relevant to international law because there is a convention, the Convention on the Rights of the Child. It is the most ratified international human rights treaty. Basically, every single state in the world, apart from the United States, has signed and ratified the treaty. And the convention, much like other human rights treaties, relies very heavily on the system of periodic reporting, right? So basically, there is a committee on the rights of the child, and every 5 years, it accepts, basically states on a rolling basis every 5 years have to report on what they have done to dispense of their obligation under the convention, right? The Holy See joined in, I think, 1990. They submitted their first report because the first report has to be within 2 years of joining in 1994. And then basically for a decade, they didn't submit a report. And obviously this coincides pretty neatly with the period during which these child abuse scandals started being revealed. And this was obviously very relevant because suddenly a major question emerged. And the question was, who was it that ratified the convention, right? If it was the Vatican City, in a sense, they're not children who are permanent residents of the Vatican City, and then any question about the child abuse scandals would become a question of extraterritorial obligations of the Vatican City. And for those who know extraterritoriality in human rights law, it's an incredibly complicated question. The issue would become slightly easier, not fully easy, but slightly easier, if it was actually both the Vatican City and the Holy See as a peculiar transnational legal person that ratified it. And basically, one of the reasons it took the Vatican City or the Holy See so long to submit a report is that they were trying to get their arguments straight. It is clear that some international lawyers were called in the room. And we see an enormous shift in the language of the Holy See between the 1994 report and the 2014 report. In 1994, you see the report saying, of course, we do so much about the rights of the children. Look at all these Catholic schools and Catholic hospitals and Catholic taking care of the orphans and of the poor around the world. So I would say in the 1994 report, it is pretty clear that they were talking about the Holy See, right? That they thought the transnational operation of the Catholic Church was directly dispensing of its obligations under the Convention on the Rights of the Child, right? Yeah. In 2014, suddenly the language has shifted. We are talking about the Vatican City. We are not talking about the Holy See. And also there is this language that says basically what fulfills our obligations is not, let's say, the provision of education by Catholic schools, is the fact that we at the Vatican City are encouraging Catholics around the world to do so. Basically, they're trying to create, arm's length relationship with these Catholic institutions that were involved in the child abuse scandals. So basically, the committee didn't have it. They said, no, we actually think you have obligations as Holy See under the convention, right? And obviously, these obligations were very seriously violated. That's like the easy part. I would say I agree with the committee's conclusion, but I thought they treated the issue a little bit as more obvious than it was because of a number of issues, including the fact that if you see the convention's wording, it talks about member states. It's not like treaties like the WTO treaties that talk about parties because we don't want to discuss the status of Taiwan, right?
Yes.
So it doesn't have these ambiguous language that treaties tend to have when they want to allow entities whose recognition and international legal status is unclear to actually join. Nevertheless, I think the committee was correct for a number of reasons, including, I think the 1994 report is pretty damning, right? Like I would say that's my best argument, that in 1994, it's clear that the Holy See considered that it was bound in its capacity both as the Vatican City and as the Holy See. I would say there is a number of other reasons, which is the ratification would become pretty useless if we are talking about the Vatican City, a place in which no children reside permanently. And I would say that, there is this broader argument that James Crawford has made that says, look, the Holy See prefers to ratify treaties using the moniker Holy See. The best way to think about it is that when it comes to treaties in which the territoriality of the Vatican City matters, for example, the Postal Union, In these cases, we consider that it is the Vatican City that has signed and ratified. We don't think that the Catholic Church all over the world has obligations to uphold in regards to like the post office.
Yeah.
But when it comes to treaties that have to do with the humanitarian mission of the church, notably human rights treaties, then we consider that it is the Holy See, in which case, of course, we have cases of shared responsibility, right? In the sense that the Holy See and the territorial state were responsible under the convention about the child abuse, right? It doesn't make the Holy See the only. There is still questions there, including whether the Holy See has a structure sufficiently resembling the hierarchical structure of the state in order for attribution and state responsibility to apply. But I think to me, the most persuasive answer is that despite the protestation of the Catholic Church and its international lawyers, it does have as Holy See human rights obligations. And I think in a sense, there is also a policy argument to be made, which is the Holy See has ratified all these conventions because they want a seat on the table when the scope of these rights is decided. And they want basically to use their participation in order to promote the teachings of a church on a number of very prominent issues, including like sex education for children or lack thereof, LGBT children and their families, abortion, and so on and so forth. So it feels to me that, saying that at the same time they're only bound as Vatican City is a way of having legal influence under the treaty without having any real legal obligations under the treaty. And that just to me feels very naughty.
Yeah.
I checked this morning. They still haven't submitted another report since 2014. So they're again extremely late. That's not unheard of. Just to clarify for our listeners, states are very bad with their periodic report, but it's clear that there is a tension between the committee and the Holy See because of the way its arguments didn't fly at all, and because, of course, of the way the committee in 2014 found multiple failures and systemic violations of the convention.
Yeah, and it's not. I mean, and to some listeners, the point you made about, or the point you made about the human rights treaty decide that the purpose of the treaty is sort of guiding your interpretation of who's a member. Some people might find that to be a real reversal. They must say, surely you should decide who it is before you decide whether, the nature of the treaty shouldn't change it. But actually, I was thinking there's a parallel here with, say, like something like the Law of the Sea Treaty, which covers all kinds of different geographical situations, right? And the bits of the treaty that apply to you, and the bits that don't. And there's a kind of similar analysis to be made there, right? Like obviously things that depend on territory, you would restrict it to the Vatican.
Exactly.
Things that don't depend on territory, you wouldn't. So yeah, so that makes a lot of sense. Okay, so look, that obviously touched on some very heavy themes. And yeah, I mean, we would hope everyone's sort of been taking care of themselves. But yeah, what it means is that this discussion, which is sort of, oh, these interesting little bodies that, are just quirky, actually, no, sometimes it does have real life ramifications for people who are seeking to enforce human rights and hold people accountable. But look, I'd like to just wrap things up now on something of a more gentle note. And note is a good choice of word here, because this week I'm asking for music recommendations. Basically, for anyone who doesn't follow my social media, I've been playing piano again pretty regularly, which I'm really happy about, but I'm running out of songs. So I'd love some recommendations. Have you guys got any old favorites or recent hyperfixations that you think I should try out on my piano?
Ooh, I mean, I've got some piano fixations. I'm not sure whether they make for good recommendations necessarily, for things to try, but certainly things to listen to. One of my favorite jazz pianists is Brad Meldau. I'm probably mispronouncing his name, and my favorite album of his, which I often listen to when I need a calm moment, is live in Tokyo, but one of Meldau's sort of specialities is he will do his own arrangements of 90s pop songs. And he's got a 15-minute piano solo jazz version of all things, Radiohead's Paranoid Android, which is just astonishing. And it takes you about a minute and a half if you're listening to it cold to go, wait a minute, I know where some of those notes are going. So you may find that interesting. I'm not necessarily sure that you want to attempt to emulate that straight off the bat.
Might be a bit outside my range just at the present moment, but it's something to aspire to. It sounds fantastic. Thank you. Dina, any recommendations?
So mine is a music recommendation that comes with a film recommendation, which is if you haven't watched Sinners, run, don't walk. I watched it last week. I'm about to watch it again tomorrow. It's the blues. So it's not necessarily the most piano-heavy soundtrack, but it does have some really good piano pieces on soundtrack. And it's the best movie I've seen in years.
Wow. Okay. Well, that is a fantastic recommendation and seems rather apt to finish on a film called Sinners when we've been talking about the Catholic Church for the last hour. Thank you so much, Douglas. Thank you so much, Dina, for joining me. We will see you next time on Call to the Bar. Bye-bye.
Bye-bye.